Hey everybody, Todd Vandermeide back again for another edition of Freedom Steel. Well, day 3 of the trial against the Illinois gun ban is in the can, and we'll have a few comments about that right after the intro. Hey everybody, welcome back. Todd Vandermeide, former NRA contract lobbyist, Illinois gun law guru, the gun Santa over on Reddit. And so day 3 of the trial against the Illinois Protect Communities Act is in the can. And it was a quasi-interesting day. So plaintiffs, our side, led off with a self-defense expert. And it was an interesting conversation from a guy who's combat veteran who is former LE and is now a self-defense trainer. And so with all that, the state tried to get under his skin, but really didn't. But one of the things that was really interesting was that the judge, after the cross-examination and all that kind of stuff, asked a few questions. And he brought up things like, threaded barrels and whatever allow for the use of suppressors, and doesn't that help other people in the house hear if gunshots are being fired? To which Mr. Watt responded, yeah, that's very important. This judge gets it in a different way, and he's got a job to do. And so part of this, there were a lot of comments in my last video harping on shall not be infringed and the full auto stuff and all that. So let's go down this road for just a minute. You can jump up and down and argue or scream shall not be infringed like you're saying Beetlejuice 3 times, and it doesn't amount to anything. Here's the world we live in. We have a directive in how the Seventh Circuit is going to look at the issues at hand. And the first issue is that semi-autos are akin to full autos. And our side, it shouldn't be this way. Under the Heller and Bruin test, it should not be this way. But this goes into a deeper subject that if the test is text, and if the text of the Second Amendment implicates conduct, that conduct is presumptively lawful, the burden shifts to the government. The Seventh Circuit, the Fourth Circuit, the Ninth Circuit want to prevent that burden shift. And what they're trying to do is take a textual argument and say that arms are not, or AR-15s are not arms as defined by the Second Amendment, even though it uses a single word, arms, to describe everything. And it's what the Fourth Circuit did. And they are trying to say, okay, Supreme Court, you gave us a test of text, tradition, and history. Fine. We're going to look at the text, ignoring the fact that Heller has already defined all the pertinent terms to the 27 words that make up the Second Amendment. They've done this with the people. They've done this with infringed. We're having this fight around the country. The Seventh Circuit has made a determination that unless there is some showing that AR-15s and the like, some magazine-fed semi-autos, are not part of the arms. And they use a line from Heller that was mere dicta about, the M16s and the like. Well, in my world, in my interpretation, in my experience, it's M16s and the like to include M60s, 240s, saws, things like that. Not semi-automatic rifles, semi-automatic pistols, semi-automatic shotguns. But I'm not a Supreme Court justice. And we ultimately want to get to the Supreme Court. And when we get to the Supreme Court, we will have to have an argument. But mind you, just a few months ago, the Supreme Court ruled that bump stocks do not make an AR-15 a machine gun. That bump stocks themselves are not conversions to machine guns. But when the Supreme Court of the United States got to the subject of machine guns and talked about that in a very general and broad way, they were not, from everything I read, everything I heard, from the oral arguments to the opinion that was issued, they are not at this time ready to say the NFA is unconstitutional and the government, whether it be state or federal, cannot regulate machine guns. As much as I would love to have a GE minigun and think that, it would be nice to be able to go down to my local gun shop once I win the lotto to pay for the ammo and buy one. That's not the world we live in. And people that are litigating this stuff on the front line have to live within the boundaries and the rules that are being laid down by the courts. That is the playground. That is the chessboard. That is where we are playing. That is where we have to operate. We have to operate within the rules and the circumstances that we are given. And if you just went up there and said, shall not be infringed, shall not be infringed, shall not be infringed, the only thing the Seventh Circuit is going to say, yeah, you lose. And then we're on to the Supreme Court. But you're on to the Supreme Court with no record. There's nothing below to buttress or say what you think on this issue, that you're right. And you can, that's it. Everybody thought in 2008 when Heller was decided that all you had to do was, chant the words Second Amendment in your brief and staple a copy of Heller to it, and voila, you were golden. In a perfect world, it might have worked that way, but we are in an imperfect world governed by men, people. And because of that, there are going to be those proclivities that nothing is as black and white as we would like it. It just isn't. That's why we've been in this litigation world for 15 years post-Heller, because the other side, the control freaks, don't want to give up a single inch. And we have to fight for all that. And we have to do it in a smart way, and we have to build on it. And as much as you can do that, but I can tell you, having been in numerous courtrooms, much less legislative committee rooms, it isn't going to get us anywhere. And we have to litigate this down to the commas. And we have to make those arguments. And in this case, it's about all the magazine-fed semi-auto rifles. And there's a big argument about that. So that's what we have to get to. And it isn't nobody that people want to give up full autos, that people want to throw somebody under the bus or anything else like that. It is merely and simply that this judge is a lower court, district court judge who is bound by the Seventh Circuit Court of Appeals above him. Even though the Seventh Circuit Court of Appeals does not feel bound by the Supreme Court as an inferior court under the Constitution. But in order to get a win at SCOTUS, we need a good decision out of a trial court. It's much better for us to have a good decision coming out of trial court and sitting there and running up the food chain and let the Seventh try to knock down, just like the Ninth is trying to knock down Judge Benitez in his rulings, and then get them to the Supreme Court. Maybe this all gets stayed pending Bianchi, which is now renamed Snope. If they accept cert, let's hope they accept cert. But that's what's going on. And that's what we're having to deal with, whether we like it or not. So you can either, that's not right, stamp your feet and do whatever, or you can roll up your sleeves and figure out how to play on the game board that's been laid out in front of us. And that's what we choose to do. So along those lines, Colonel Tucker, the infamous Colonel Tucker, who said that a single shot from a .556 round would decapitate somebody or remove limbs or things like that. And with all that, he was up there. His testimony was meh at best. Colonel Tucker admitted he did not read the entire act, did not look at all the guns, and was just there to comment about some doctrine and that the military uses semi-automatic fire, and therefore these guns are the same. His testimony in my world is of limited value. The state is hung up on one full auto fire, hanging their hat on pretty much everything the Seventh Circuit said about M16s are the same side of the coin, just the opposite side of the coin as AR-15s. It doesn't matter. And that everything has to be used in self-defense. This absurd notion where they are taking the words that, self-defense is the most sacrosanct part of the Second Amendment, but they seem to want to continuously omit the words from the holding for all lawful purposes, such as self-defense. They just want, for the lawful purpose of self-defense, but that's not what the Supreme Court wrote. So today is the final day of the trial, I believe. Today the state will put on another witness. It's probably going to be another lackluster individual. I think then after lunch they'll probably get the closing arguments, and we'll see what that all looks like. We hear the state's going to try to make some motion about objecting to a bunch of the documents and things that we are putting in the evidence. The other day when I was there, they wheeled in no less than 8 bankers' boxes of exhibits for our side. And I think that's kind of driving the other side a little nuts with the volume of information that we're trying to put into the record. So with that, it's early. I've got to get out to the club and move some dirt today and take care of some big deliveries we've got coming out to the club to keep things there rolling along. So as always, please, thank you for watching and paying attention. Please smash the subscribe button, copy and paste this link, share it around to your social media sites and all the like. And as always, frag out.